I'm Jason Herman here on behalf of Mary Awaniki. I'd like to reserve 5 minutes, please, for rebuttal. All right, this case involves two issues. The first is whether SafePoint can use 627-70131, a statute that literally is entitled Insurer's Duties, to impose an unwritten duty on its insured that ends its claim. And the second issue is whether the trial court got it right when it ruled that Ms. Iwaniki had presented sufficient evidence that SafePoint had picked the repair vendor here to do the repairs. So going to that first issue, SafePoint here contends that if an insured files suit within 90 days of a claim, that claim and that suit is forever gone, and judgment should be entered in favor of the insurer. Now, setting aside the fact that here 90 days had actually gone by between the claim and the suit, that legal argument doesn't work. So this court addressed a very similar argument in the Curtis versus Tower Hill case, where Tower Hill argued that the suit had been filed prematurely and pointed to two different things. One was the loss payment provision and the timing that was based on proof of loss. That argument was also raised here below, accepted by the judge, and has been abandoned on appeal. The second issue in the Curtis case was the neutral evaluation statute, which is a non-binding ADR process for sinkhole cases where insurance companies are afforded the right to pay at the end of that process while litigation is stayed. And if they do, it rewards them with reduced exposure, possibly avoids litigation. In Curtis, the insureds sued Tower Hill in the middle of that process. And the insurance company said, you've violated the conditions, you've sued too early, now your case is over. Trial court agreed. This court disagreed, though, and reversed, and looked in doing that, compared that neutral evaluation statute to the Med-Mal statute, made that analogy, where the Med-Mal statute has a prohibition on litigation after the pre-suit notice. The neutral evaluation statute just has stay. And so this court held, even though the insured sued while the neutral evaluation was going forward, their breach of contract case could go forward. It was not barred. So let's talk about the statute in this case, the 90-day insurance statute. And I do want to talk about it in the context of the Med-Mal statute and the neutral evaluation statute, because I think it illustrates the three different levels of restriction that our legislature can put on lawsuits. So in the Med-Mal situation, there is a prohibition on filing suit for 90 days after the pre-suit notice. In the neutral evaluation statute, our legislature has stayed litigation. And then in the 90-day statute, we've got the lowest restriction, none at all. There's no discussion at all about whether an insured can file suit. Also, when you look at that neutral evaluation statute, that statute actually imposes bilateral duties. So it has duties it places on the insured, not just the insurance company. Most notably, an insured is required to participate in neutral evaluation if it's demanded by the insurance company. On the 90-day statute, there are no such duties. It's a completely one-sided statute that just imposes an obligation on the insurance company to adjust claims in 90 days. And the penalty for an insurance company not doing that is really rather light. It's interest that's added on to the amount that's owed. And that statute, 627-70131, does not afford an independent cause of action to an insured for a late paying insurance company. So in other words, if the insurance company pays late, but pays the right amount, the insured is left with no recourse. So here, SafePoint urges this court to impose a duty on the insured not to file suit in 90 days, which is nowhere in the statute, and then to impose an even stricter, harsher result for violating that unwritten obligation. And in fact, that result is harsher and stricter than the result for violation of the Med-Mal law. So the Florida Supreme Court in 1990 held that if a plaintiff files or serves their notice the same day they file their suit, the result is a dismissal with leave to amend. It's not death to the whole case. And that's the hospital court via Lindbergh case. So the idea that a lawsuit is fatally doomed because it's filed prematurely, it just is not in line with Florida law. But here, we didn't get to the issue of prematurity because SafePoint didn't raise the 90-day statute in its answer. It's nowhere in the pleadings. And then it didn't move to stay, didn't move to abate, which would be the normal procedure if an insurance company is actually considering paying more money because they're still investigating the claim. And let's be clear, if Ms. Iwaniki had waited 90 days instead of 21 days, she wouldn't have been paid anything. And we know that because of the affirmative defenses and what was said during the trial. When SafePoint's, this is page 6 of the first day of trial, SafePoint's lawyer identifies himself as a fraud specialist to the court and says, this is the worst case of fraud I've ever seen. And then in opening statements, tells the jury, this isn't about a water loss. It's about greed and fraud, pure and simple. So if she had waited 70 more days or 700 more days, she would have faced the same result, which is a non-payment of anything else. So SafePoint in this case affirmatively took the position, nothing is owed here under the policy. Ms. Iwaniki took the position, something is owed. That's a classic insurance dispute that should be resolved by a jury. And as I started with, the idea that 90 days had passed here is not factually supported. So this claim was reported in January. The lawsuit was filed in May. That's more than 90 days. For SafePoint's argument to work, it has to transform the proof of loss that came in into a claim or a supplemental claim. And under the Milholm versus Tower Hill case, a supplemental claim is a claim for new stuff that's discovered during construction. It's not a claim for the same damages that arise out of the same causality. Yes, the claim here was bigger than what was claimed. That's a frequent area of dispute in insurance cases, but that doesn't make it a supplemental claim. And even if it did, this was presented in the form of a proof of loss that was requested by SafePoint pursuant to its policy. And that policy in the loss payment provision kicks off a few deadlines based on the proof of loss. One of them is that if the insurance company agrees with the proof of loss, it has to pay within 20 days. That didn't happen here because obviously, as is clear from trial, SafePoint did not agree with the amount claimed. That left Ms. Iwaniki with two options. She could have demanded appraisal. She chose not to. It was not required in this policy. The other option was to get a judgment. That's the other prong to get paid under the loss payment provision. That necessarily contemplates a lawsuit, which is what this court recognized in the Curtis case. So the policy here contemplated this lawsuit. The law didn't prohibit it. And so she should have been allowed to go forward with it. And this case should not have been ended on directed verdict as to count 1. Moving on to count 2, which was the opt to repair count. The law here is that if an insurance company selects the repair vendor, then they have opted to repair. And in the Drew versus Mobile USA case, there was a dispute on whether the insurer had opted to repair. The insurance company there testified, we gave 2 referrals. We didn't force the insured to use either one. The insured testified, we weren't given choices. We weren't told we could use our own repair vendor. And that was enough to create a fact question. In that case, it was a reversible summary judgment, a fact question. Here, this is the evidence that there was an opt to repair presented at trial. SafePoint initiated contact with Paul Davis, not Ms. Iwaniki. Paul Davis actually testified that it received the assignment from SafePoint, not from the insured. When Paul Davis arrived at the house, it started on work without getting instruction from Ms. Iwaniki, which means who did it get instruction from? Most likely from the last person it talked to, which was SafePoint's adjuster. The normal procedure of a homeowner hiring a contractor didn't happen here. There wasn't a quote given to Ms. Iwaniki. There wasn't an estimate. There wasn't a bill even given to her. It was all direct billed through SafePoint, who direct paid. Yes, Ms. Iwaniki did let Paul Davis in the door. She did sign a work authorization, allowing them to begin the work. But that doesn't mean that she picked Paul Davis or that she had a choice there. She had a choice on who to let in the door or a choice on who to authorize out to do the work. And there's no evidence here that SafePoint ever advised Ms. Iwaniki that she had an option here, just like in the Drew case. There's not direct evidence of you don't have to use Paul Davis, you can use whoever you want. This is just a referral. Instead, what SafePoint points to is that in the initial conversation, the adjuster asks Ms. Iwaniki, do you already have a repair contractor? And what they argue is there's a reasonable inference that can be drawn from that she did have options. I'm not saying that's wrong, but there are reasonable inferences that can be drawn from the other evidence that she did not have options. And when you're talking about inferences and what should be drawn from them, that's
have to be drawn in favor of the non-movement for directed verdict.
Absolutely. And if we got non-direct evidence on this, it's the classic thing that a jury should decide, not a judge. And as for SafePoint's other arguments, they made arguments that have now been abandoned. Here on appeal, the arguments are this was not in writing, so therefore it doesn't count. That's the facts of Drew. In Drew, there's, just like here, there's a standard option to repair clause that says that the repair option should be made in writing within 30 days of a proof of loss. That's great when that happens, because then we don't have jury questions, we don't have issues of fact. But what Drew focused on was, who picked the repair vendor, what actions were taken, not just what was put in writing. If you imagine a adjuster coordinating to put a tarp on someone's roof after a hurricane, and instead of keeping water out, it directs water into their living room, there's going to be liability there, whether there's a written letter or not. And then the last issue is whether water mitigation is a repair. Of course it's a repair. It's the first step in making a repair. Repair is how you return a damaged property to its pre-loss condition. If it's dry before and it's wet afterwards, the first step is to dry it out. And as far as remediation goes, that's also the facts of the Drew case. There it wasn't water, it was mold, but neither Paul Davis nor the remediation company in Drew were building walls. They were doing the first steps. Let's get the property ready for new construction to happen. So for these reasons, Your Honors, we ask that you reverse both entries of directed verdict on both counts.
Okay, thank you, Mr. Herman. Ms. Russo.
Unmute. May it please the court, Elizabeth Russo on behalf of the appellee SafePoint Insurance Company. Just briefly, by way of response to that, we are not basing our argument on 627-70131. We're basing it on our contract, which happens to mirror the language of that, but makes a contractual obligation. Number two, the trial judge did not rule that there was a fact issue on the option to repair. She granted directed verdict on it. We think that the directed verdict was proper as to both the breach of contract claim and the breach of the option to repair. And so starting with the breach of contract, SafePoint was not in breach of any provision in the contract at the time the suit was filed. And to look at that, we go to the events just briefly before the suit was filed. On January 2, the plaintiff sustained her water loss. On January 3, she called SafePoint. SafePoint had an adjuster get in touch with her that day. And the adjuster asked her, this is a water loss? Well, do you have a water mitigation company? And Mrs. Iwaniki said she didn't know what to do. So a water mitigation company was recommended. Then the adjuster came out 5 days later on January 8th. She looked around the house, did measurements, asked the plaintiff to show whatever areas of damage there were. And she then went and prepared an estimate based on what she had seen and sent checks to pay for the damages based on her estimate. It was sent with a letter that said, but this is not necessarily a full and final payment. You can make supplemental claims at any point that you want to, if you have something else. And Mrs. Iwaniki actually called her and said, I think there's a couple of items that you've missed. And the adjuster agreed and sent her 2 more checks. So The plaintiff still had one other area, something else that she thought there was a hole in her bedroom wall or something that she thought they hadn't allotted enough for the drywall and the paint. So the adjuster said, well, wait and see what the contractors charge you. And if you need to, then you can make a supplemental claim. So then we hear from, well, that all ends on January 19th, us going back and forth. And then we sent the additional checks that I think were dated January 30th. But we haven't heard anything from Mrs. Iwanicki from January 19th on. And we haven't received anything about is she doing repairs or no documentation about the claim. So on February 2nd, we wrote to her and asked her, please give us the names of your repair people and any repair receipts you have and a sworn proof of loss, which we have to request under the policy terms. And if we request it, she has 60 days to then give us the sworn proof of loss. But we hear nothing from her from January 19th until April 18th. As it turns out, she was doing things, including hiring her attorney, and they were doing things, but they didn't tell SafePoint about any of them. The next thing SafePoint hears from her is receiving this sworn proof of loss dated April 18th. It's not clear from the record when SafePoint was furnished it, but let's just say April 18th, taking the facts in the light most favorable to her. Now, the sworn proof of loss comes as a complete surprise. She's now claiming $105,000, I'm just going to give rough figures, but $105,000 for building repairs, $44,000 for contents repairs. And by the way, when the adjuster was out there and met with her on January 8th, she asked her, do you have any contents damage? And Mrs. Iwanicki said, no contents damage. And she confirmed that at the during trial. So this is coming directly from her. The question is, the only thing you told my client SafePoint on January the 8th is I have no contents damage, correct? That is correct, says the plaintiff. So $44,000 worth all of a sudden is quite a surprise. And then $15,200 for additional living expenses, but those are only owed on an as incurred basis. And she testified at trial that she had not incurred any additional living expenses. Now, what the policy says is that this is now our first time getting any of these numbers, is that we get 90 days to pay or deny. And that's a condition in the policy.
That's not, you get 90 days to pay or deny after you get a proof of loss. 90 days to pay or deny after you receive notice of the claim.
Notice of the claim, but this is the first, it's not notice of the loss, it's notice of the claim.
Yeah, so she made the claim in January.
She reported the loss to us in January, and we went out and started the process and started the payments, but the claim.
So on what day did you get notice of a claim?
We got notice of the loss on January 2.
Well, wait a minute. A loss is covered or it's not, and you know, certainly you can have a reservation of rights and everything, but you sent people based on this notice of whatever this was, right?
Yeah. Yes. Did you say? Did we?
I was suggesting to you, and again, devil's advocate, and we're on a directed verdict here, that you had notice of the claim in January.
And notice of but we told her, we paid and told her if you want to supplement your claim, and she referred.
Well, you can call it a supplemental claim.
Yes.
I mean, we've got different definitions of that. It's a supplemental claim defined in the policy.
No, it's not.
It's all the same. It's all from the same incident, correct? Same cause of the law.
Yes. But the plaintiff herself, when she was describing the subsequent checks we gave her, called them supplement payments. It wasn't that any.
Is she a lawyer? Is she a lawyer? I mean, you know, we're using a term of art here.
She understood it. We had told her, if you want more, make a supplemental claim, and she did.
Or let us know how much more it is, and we'll consider that. Whatever you want to call it.
That's right. And she did.
All right.
on April 18th, that's the first time she gave us any numbers of any kind, and she admitted that. She never told us anything before that, so we can't be guessing.
So you're saying that the proof of loss equated with notice of claim,
Equated with.
even though
notice of
the
supplemental
policy
claim.
uses those terms, two different terms for that. One is a notice of claim and one is proof of loss.
It's after we receive notice of an initial, reopened, or supplemental property insurance.
Right, but you're saying you didn't have a notice of claim until you got that proof of loss.
No, I'm saying that acted as either a reopened or a supplemental claim.
How so? I mean, is that the case in every time you have a claim and then you get a proof of loss afterwards?
Well, we had made the initial.
If you get a notice of claim,
Yes.
and then afterwards you get a proof of loss, that is different. You know, and these things happen. You know, and we'll get a proof of loss. The numbers are higher. That restarts your 90 days from a notice of claim.
Well, it's when we get some kind of numbers from the insured to.
Well, that's not what this says. That's not what this says. You're talking. You know, again, you got a directed verdict.
Yeah.
Okay, where in here does it say when we get some kind of numbers?
Well, we had made a payment on the claim.
I think that, yeah, but you got a directed verdict based on what you say is contractual provisions that she basically waived her rights because she sued too early. And so I'm looking in the contractual language for that, where that is true. And you're arguing, well, it wasn't fair because we didn't have the numbers already. Well, that's not the language in the contract.
Well, let's.
And you've cut off this woman's right to get to a jury, and you've cut off basically her coverage as a result. So I think that we need really more than that.
Well, let's look at the contents claim, for example. She told us in January when we were there that she had no claim for contents coverage. She said she had no contents damage. The first we heard about it was when
Well, yeah, and then, people can discover contents damage after the fact, after they give you notice of the claim, can they not?
But she had told us that she had no damage.
So
no
she's
claim
bound
for that.
by that forever?
Huh?
She's
No,
bound by
it does
that?
not. It does not.
Did she
But
fill out a claim form?
when she did she fill out a claim form?
Yeah, did she give you a written notice of claim that said
No.
that?
No, no. So to us, the first notice that we have of a claim for contents damage is when she gave us the sworn proof of loss.
So wait, let's come back.
That's the wording of the policy. Notice.
The policy says in one place, proof of loss. And another place it says notice of initial, reopened, or supplemental claim. And you're equating the proof of loss with the notice of the claim.
Now, I'm just saying, under the facts of this case, we had
We're looking at the terms of the contract, because that's how you got your directed verdict.
Well, I'm talking about the terms of the contract.
So where does it say
Within
first
90
time we
days
hear?
of when we
First
receive
time we get so many days from the first time we hear the numbers.
I'm saying the first time she made a claim for the contents damage happened to be in a sworn proof of loss. She could have called us on the phone and told us it, but the first notice that we had of it was when we got that sworn proof of loss. I'm not saying the sworn proof of loss is a notice of claim. I'm just saying in this case, there's no.
So you could have notices of claim at different points during I don't know what you call this process. So the first notice of claim is, oh, I've got damage here from water. We don't know how much it costs yet, but that's a notice of claim, wouldn't it be?
Well, why would
she's notified you of an event that is causing her damage. And then the next one would be, well, we got a bill from the mitigation contractor here. Oh, okay. Is that another notice of claim? I mean, every time a new bill comes in, is that a new notice of claim?
The statute, our contract says initial, reopened, or supplemental. So clearly.
Well, I'm asking you though, where are those terms defined in the policy?
They are not.
Like reopen suggests that the claim has been closed. Did you have any evidence that this claim was closed?
Just that we had not heard from her for.
But you hadn't.
And
Okay.
she said, if you have a supplemental claim, then give us.
Well, yeah, but your agent saying that, using that word in her conversation with her isn't the same thing as defining this term legally in the contract, is it?
No, it's not a definition from the contract.
Okay, so what makes this a supplemental claim within the contemplation of the contract? What are the terms in the contract that makes this a supplemental claim?
The fact that we had told her in the letter, we made the payment that based on our estimate, if you want to make a supplemental claim for more money,
so
then
that letter basically defines the terms in the contract.
the letter said make a supplemental claim.
What if the letter was using the wrong term?
It's using the same term as is in the contract.
Oh, I know, but what does that mean? What does it mean in the contract? When the contract says supplemental claim, what is the definition of that term in this insurance policy?
Claim for supplements to the payments you've already received.
So you've closed out this claim, and this is supplemental to that claim, or is this part of the same claim?
I think it's supplemental to the original amounts that we paid. She wants
so every time you paid an amount to a contractor, that was a supplemental claim?
I don't understand that question.
Well, you said I think you paid at least twice and maybe 3 times you sent checks?
Twice.
Was each time based on a supplemental claim?
We paid the initial claim based on our estimate, and the second time we sent her a supplemental. We told her. And
so if you give her money based on your estimate,
mm-hmm.
That's a claim. And then if it turns out the estimate was low and you give her more money, that's a supplemental claim.
If she presents it that she wants additional money, yes.
Okay, and that's defined here in the policy somewhere?
I've said it's not defined in the policy, but I think
and yet the policy uses that term, and you rely on that term to cut off her right to pursue this claim to a jury.
Not to cut off her rights. It's just we need.
You got a directed verdict on that basis.
Hmm? Well, I think that our position is that this policy language gives us, you give us a supplemental claim, and I think it's a supplemental claim because we paid once. Now, 2 months later, you come up with, these are the numbers that I want. Okay, now we need to look at this and have, because otherwise, after we make the first payment, we don't get to investigate. The sworn proof of loss comes in, and 2 months, 3 months later, and we're supposed to just get no time to investigate that? That doesn't.
Well, excuse me.
Go ahead.
Ms. Rousseau, hasn't our case law, though, in our court said that these loss payment provisions really control the time of delivery of the payment and that they shouldn't be used as a bar to an insured suit to bring suit here? So how can we reconcile that case law with the facts here?
Well, the case law, Curtis and I think Skeen decisions, we're basically dealing with the first part of this, our provision, which says we'll pay you within so many days of either a written agreement or appraisal or a final judgment.
Basically, essentially the same idea here in this proof of payment of loss provision.
I'm sorry?
Curtis really had the same setup as this policy in terms of paying the loss.
But what they were relying on was in Curtis was what time you pay within the time of reaching a written agreement or an appraisal or a judgment. We're talking about the 90-day provision when we're given this what I am calling a supplemental claim. I think it's a simple term, but we get 90 days to try to look at it and to pay it. There were,
But why should we not apply that to these facts here?
because we
Why
need the 90 days. We need, I'm not talking about the lost payment as you know, after we reach agreement or whatever. That just tells us what amount of time we have to pay when one of those three events happens.
But you're saying it shortcut your investigation period and your obligations by them bringing suit before the 90 days expired.
Yes, that's exactly what I'm saying. Because if we're going to use the date of the initial reporting of the loss claim, then it's fine for an insured 90 days later to come up with a completely unexpected estimate. And we have no time to investigate it at all. That's what the policy was designed to give us to do. For example,
Maybe. I'm just looking at the terms of the policy, and I'm trying to understand them in terms of what the policy meant to this lady.
well, I think well, I would like to mention just the statute, not that we're saying that the statute creates a condition precedent. It's the policy that creates the conditions. But they've looked at what's a reasonable amount of time for an insurer. We're going to tell you insurers, you're going to have to pay within a certain amount of time, but 90 days is what we've come up with as come on, do your investigation and pay or deny all or a portion. And that was put into our policy to give us the 90 days. Now, what are we to do, make of these numbers, whether you call it a sworn proof of loss or whatever? This is the first notice that we have that you're claiming $105,000, which we are later given when we're in lawsuit already. We're given two estimates that show that it's $30,000 more than her own estimator estimated. And then we're given this $44,000 in contents claim that turns out to be for mold. But we find out in the lawsuit that she had actually hired a water restoration company herself during February and then fired them early. And they told her, if you do this and we cut off our work in the middle, it's going to create mold problems and secondary damage. So how we needed the 90 days to be able to figure out, well, wait, how much of this is actually owing under the policy so that we can try to do what we're supposed to do, which is resolve claims outside of litigation.
So you're saying, though, like, might the policy have said we will be obligated to pay not before 90 days after we receive this notice? I mean, that seems to be how you're interpreting it.
I'm saying that I think it's a condition in the policy that us having that obligation means the insurance.
You're not answering my question.
Sorry.
As you interpret this, what you're saying is that you have no obligation to pay before 90 days after receiving. Okay, but that's not what it says. It seems to, what it seems to do, on the contrary, I think, as Mr. Herman points out, is it seems to impose a deadline that you have to pay within the 90 days.
Right, but we put that in as a policy condition for the insured as well. So you need to give us the 90 days to be able to, because we don't have a contractual obligation to pay you before. We have to get you paid within 90 days, but that gives us the 90 days, and we are not in breach if we haven't paid you before the 90 days runs out. We have to have the time to investigate.
And okay, never mind. All right, I've really helped you take up all your time, as we said. So I'll turn to Mr. Herman now.
Just like in Curtis, where the neutral valuation was partially written into the policy there, the 90-day insurance law is partially written into this policy as well. And what's interesting is that in this policy, it actually refers, it's the 90-day statement is in subsection C of the loss payment provision, and it says in the policy, you can't sue us for this alone. So it explains how the insurance company cannot be sued for violating its deadline, but is completely absent of any kind of consequence to the insured, as well as any duty on the insured in that 90-day period.
Right, and so you're saying that Curtis involved the 60-day, paragraph B, 60-day, correct? And
Yeah, as
whether
well
you had, I'm sorry?
Yeah, it did. It involved the first A and B portions
Right.
of the loss payment provision.
But they're arguing this is, are they subsumed in C, or what's the story here? I mean, does that make no difference that they're proceeding under C here?
It makes no difference. The other thing is that C it's a strange tack on to this loss payment provision because it's trying to put in this deadline to adjust claims into a loss payment provision, because C contemplates, just like the statute, not just payment, but denial as well. It's that you've got to make a decision within as a deadline of 90 days. And so where A and B, which, B has two subparts, those are three options for payment. C is not really an option for payment. This is just, we're going to adjust your claim within 90 days.
We will pay or deny.
Correct. Yeah, we will pay or deny. So unlike, if you actually just read the sentence, the intro sentence to the loss payment provision, it is a full sentence with A and B, and it just doesn't make sense with C. But that's because this is meant to reflect the statute, which, all insurance statutes are incorporated into policies anyway.
Right.
But the other thing here is there was a question about when the notice of claim came in, and we know that from SafePoint's actions, they made claim payments on this. They made two claim payments to Iwaniki. They also made a payment to Paul Davis. That was their third payment you were thinking about, which is the vendor they paid directly for work on the claim. The other thing is when we look at the idea of a supplemental claim versus a proof of loss, even if somehow you can say a proof of loss can reasonably be interpreted as a supplemental claim, now we're getting into ambiguity issues because.
Well, yeah, I mean, as I'm reading it, they pay within 90 days after we receive a notice of an initial, reopened, or supplemental claim. Well, this course was beyond 90 days after they received the initial one in any event, correct?
Absolutely.
And it doesn't say it restarts 90 days, restarts on the reopened or supplemental, whatever that is.
Right. And I think it certainly is a reasonable interpretation to interpret a proof of loss as being something different than a supplemental claim. They're different words, they're used in different places. And so even if both of us here are arguing reasonable positions, the tie goes to the insured on this. I mean, that's ancient insurance law in Florida, that ambiguities are construed in favor of coverage in favor of the insured. I mean, the other thing here is that if SafePoint here is surprised by this proof of loss, it has options. For one thing, 627-70131 requires a response to written correspondence within 14 days. But regardless, they had 20 days to write a letter that said, we'd like to investigate further, take an EUO, ask for documents, ask for a reinspection. All these things put duties on the insured, and those duties would create a big problem if you file suit when those have not been complied with, because the policy puts affirmative duties on the insured to comply with EUO requests, comply with document requests, comply with inspections. That never happened here.
Your rebuttal time's up, Mr. Herman.
All right. Thank you, Your Honor. We ask
Thank
that
you both very much.
Thank you.
Okay. In order to leave this space, click the leave button in the lower right-hand corner of your Zoom screen, and then you'll be gone.